And our final case for today is People versus Langston. This is a grant, a 30-minute argument per side. We have Ms. Edmonds and I believe Ms. Simbelman, you are going to share some time. So share some of that 30 minutes. And Mr. Restuccia, you will have your full 30 minutes. Again, 2 minutes of fire-free zone that you can waive, and if you would like rebuttal time, feel free to reserve it.
Good afternoon, Madam Chief Justice, and may it please the Court. Mira Edmonds from the University of Michigan Law School on behalf of Mr. Edwin Langston. I will be addressing the retroactivity issues today. Ms. Simbelman will be focusing on the sentencing issues, and we will attempt to reserve 6 minutes for rebuttal. I will keep my own time. 45 years ago, last month, this court issued its seminal decision in Aaron, resolving a split in the lower courts and establishing that a person cannot be convicted of felony murder without a jury finding that they had the mens rea for murder, that is malice, rather than simply the intent to commit the underlying felony. The court applied that decision to the three Aaron defendants and defendants in 2 other cases. But without briefing, argument, or providing any reasoning, the court stated in one conclusory sentence that its holding would apply prospectively. That apparent statement of prospective-only application was wrong under the law then, and even more clearly wrong under the law today. This court has the opportunity to right that wrong and finally hold what the Aaron court should have held long ago, that its holding applies to defendants who were on direct appeal at the time and on collateral review. The most straightforward way to correct this error today is to vacate Mr. Langston's conviction and those of similarly situated defendants because the jury never found that they had the mens rea for murder, which is an essential element of the offense. That is, this court should provide the remedy that Mr. Langston and others received from the Court of Appeals 4 decades ago, before the Aaron court inexplicably reversed those decisions. This court is not constrained by stare decisis on this issue and is not constrained by the law of the case. Stare decisis is not an inexorable command, and where a decision is badly reasoned, or in this case lacks any reasoning, the court owes little deference to it. Law of the case is similarly not a limit on the court's power, and the doctrine does not apply if the court is convinced that its prior decision is clearly erroneous and would work a manifest injustice. The Supreme Court's failure to apply Aaron in the cases of Mr. Langston and many others, despite clearly erroneous jury instructions that either omitted or created a conclusive presumption of malice, has caused the actual inequity of similarly situated defendants being treated differently. That was and remains a manifest injustice. I welcome the court's questions at any time. Aaron should have then and should now be applied to Mr. Langston's case because the Aaron court decided what the murder statute means and has always meant. It was not interpreting the common law, it was not legislating, and it was not merely dictating a policy shift. Aaron also applies to Mr. Langston's case under this court's decision in Poole last term and Gay because the Aaron rule is substantive, as the prosecutor concedes, or under Linkletter-Hampton because the purpose of the rule predominates in the analysis, and the purpose was to ensure the fundamental right to have all elements of the offense proven beyond a reasonable doubt. Or, as Justice Levin noted in his Lonchar dissent, the purpose is to realign criminal responsibility with moral culpability. Now, the prosecutors tried to muddy the waters by discussing the facts of other cases and by suggesting various standards for assessing the evidence presented at trial, but the only question is whether the jury found the mens rea for murder. In Mr. Langston's case and many others, the jury never made that finding. The court should therefore provide the remedy that the Court of Appeals provided in 1978 before Aaron and consistent with Aaron, vacate Mr. Langston's conviction and remand either for retrial or for entry of a conviction of manslaughter, which is a killing without malice, or armed robbery, as those are the only convictions that can be sustained by the jury's verdict, and he should be resentenced accordingly.
Counsel, how do you, given that your client obviously already had an appeal here, and obviously it didn't go the way he had hoped, how do we get around the procedural bar? I mean, do we have, you know, the law has morphed over time? I mean, how do we get past 508D3? Or does 508D3, is there something that applies that allows us to basically get to the argument you're advocating for?
Yes. So as I noted, first of all, with regard to the law of the case, I think that need not be applied in this case. In addition, Mr. Langston can show good cause should be waived, first of all, because of the significant possibility that he's legally innocent. But he can also show good cause and prejudice. The Aaron-based challenges were not, in fact, ripe until after Aaron was decided. So because the Court of Appeals decision that actually the prosecutor was appealing in his case predated Aaron, and it wasn't until the court decided in Aaron, or made this prospective-only statement in Aaron, and then began issuing these orders in all these other cases, effectively denying leave, that claim became ripe.
Didn't Mr. Langston raise this argument in his appeal?
In
his direct appeal?
Yes, he did, and the Court of Appeals decided in his favor. And then there's some confusion in the procedural mishmash, but essentially then this court, in his case and in about 30 other cases, again in one line, essentially denied leave, or in his case because it was a prosecutor appeal. There's also the due process challenge, which was presented in Aaron but not decided by that court, and Mr. Langston raises that claim here as well. And there's prejudice because his conviction and the conviction of many others stood, even though they were similarly situated to, again, the three defendants in Aaron. Then there was Wilder, which this court treated as a companion case because it happened to be discussed in the same conference. Leave happened to be granted on the same day. And then in a fifth case in Butts, the court said, well, actually, because Butts is a co-defendant of Wilder, we're going to apply Aaron there as well. But then as to everyone else, we won't apply it, really with no principled basis.
So let's talk about the remedy question. And I know that Ms. Simbelman will address it too, but I'd like to hear your thoughts on it. What is the problem, say that he's entitled to relief, or we agree with you on that, with the sort of more as-applied approach that, you know, where the defendant makes a showing that there wasn't the instruction, and then the burden shifts to the prosecutor to show that there wasn't sufficient, that there was evidence of sufficient malice. Why is that a problem? As opposed to the more just categorical, if the defendant was convicted where there was no instruction, then they're entitled to the remedy.
So with respect to Mr. Langston, I think it's very clear from the record already that he did not have the proper instruction. And so that, I think, is pretty straightforward as to what the court can give Mr. Langston that remedy. Again, the same remedy the Court of Appeals gave him in 1978. With respect to other defendants, I think there are real issues of fairness because these cases are so old. They all predate 1980. Some of them are from the early 70s, the late 60s. It's very difficult for an incarcerated defendant to locate necessarily the jury instructions. And I think that's problematic. What the prosecutor's offices have a duty to retain records, a statutory duty spelled out in greater detail in the regulations. So I think putting that burden on defendants in these particular circumstances where we're talking about trials that happened so very long ago is likely to compound the injustice that was done in their cases. In addition, it's really the error here because malice is, as the Aaron court says, the grand criterion that elevates a homicide to a murder. So it's not just any element, it's really a fundamental, an essential element, as the courts say. And so the standard there should be different perhaps than in another case. And arguably it's, and actually as is stated in I believe it's the Aaron concurrence, it's a conclusive presumption, which basically takes that fact question away from the jury entirely. And there are ways in which malice not having been included in the jury instructions really could have infected these cases throughout, right? It could affect what defenses are raised, what evidence is presented, what testimony is presented, what arguments are made, what objections are made. And so to try to, at this point, figure out how exactly the lack of malice instruction may have affected those cases would be very difficult, verging on impossible.
So you're saying even if the factual record could be determined, and the prosecution makes an argument that look, even though they weren't instructed, there was sufficient evidence of malice, it's sort of like putting the toothpaste back in the tube, that record is tainted by the lack of, like the evidence that was entered was tied up in the fact that there was no instruction on the malice.
Exactly. If the record can even be located.
Right.
Yes. If there are no further questions, I'll turn my time over to Ms. Zimmelman.
Good morning, Your Honors. Jessica Zimmelman from the State Appellate Defender Office on behalf of amicus criminal defense attorneys of Michigan. What's going on here is uniquely cruel, and I think that's why this court and the parties may be struggling to come up with an appropriate remedy. Essentially, based on a single conclusory statement from this court in 1980, people have been kept in prison for much longer than their jury verdict would allow for. But to answer your question, Chief Justice, about why we shouldn't essentially have a two-step inquiry, as the prosecutor has suggested, where you show jury wasn't instructed and then we try to measure levels of malice. There are two big problems with that. One is a Sixth Amendment problem. Because while this court in Skinner talked about how life without parole for young folks is not an element of the offense, and it cited to Tyson and Edmund from the U.S. Supreme Court. That's not what we have here. So there would be Sixth Amendment problems going back to try and retroactively determine the amount of malice, evidence of malice that was presented at trial. So that's one problem with trying to measure malice. The second is what you and Ms. Edmund discussed, is this is not typical to your typical harm analysis. Because a trial could have looked very different if all the parties knew what the instructions would look like. Take, for example, you're a trial attorney back in the 60s and 70s. Your client is facing a felony murder charge. You know as a trial attorney that your client can be convicted and sentenced to life without parole based on the commission of a felony. You probably in those circumstances would never put your client on the stand to testify about their participation. If the jury was going to be instructed consistent with Aaron, however, and the client agreed, yeah, I was there, there was an armed robbery planned, I was the getaway driver. You might put your client on the stand in those circumstances to testify about their actual role in the offense. So essentially, by these juries not being properly instructed, you can't unring this bell. The whole trial would have looked fundamentally different. So this isn't a circumstance that is amenable to this court's typical harm analysis. And we also know when we're looking at the sentencing piece of this, if the simplest solution is that this court should hold that Aaron was retroactively applied, no deference is due, as Ms. Edmund has already discussed. But if this court gets to the sentencing piece, why would we impute a jury instructional issue to a sentence? And that comes from Aaron itself, where this court in Aaron said the felony murder rule erodes the relation between criminal liability and moral culpability. And anytime we're looking at this court's cruel or unusual punishment jurisprudence or the United States Supreme Court Eighth Amendment jurisprudence, there's always this discussion of moral culpability. And what we have here, we don't have a jury finding beyond a reasonable doubt that people who were not instructed are in fact morally culpable and deserving of the most severe punishment. I also want to point out for this court, as it considers what remedy to fashion here, that we don't create remedies based on who we don't want to benefit from the rule. The prosecutor talks at length about specific factual scenarios of people convicted of felony murder pre-Aaron, and establishes actually in their briefing some bright line rules for this court to consider, that if you were the principal, you shouldn't be entitled to resentencing. If offenders who assisted in the murder itself, no resentencing. Where the evidence of a depraved heart was clear, no resentencing. But again, because of the problems that infected these trials from the very beginning, because they weren't properly instructed consistent with Aaron, those bright line rules cannot be bright. We need to focus on the personal and moral culpability of people who were not ever found guilty beyond a reasonable doubt of committing the most serious offense in Michigan.
Ms. Simbelman, can I ask just for a clarification? There was a split of authority pre-Aaron about the instruction, right? So there is the potential that some defendants convicted under Aaron did in fact have an instruction.
Yes.
So this idea that anyone pre-convicted, should get the remedy, that might be a line too far.
That is, if that's what the court heard from my statements, I apologize. What the remedy we are specifically asking for here, if this court finds it to be retroactive or if it goes to the sentencing issue, only turns on whether a jury was properly instructed. So if a jury was properly instructed consistent with Aaron, then unfortunately that person is not entitled to relief.
So
we are focusing on the group of people here, a subset like this court addressed in Lyman, a subset of people where their juries were not properly instructed.
Okay.
And
So how would that work? If I agree with you, how would that work?
I was just getting to that point, Justice Welch, because there is a lot of confusion and it's a messy remedy at least 45 years later. But I think where this has to start back in the trial court, and we can look to this court's decision in Taylor as a model, although that might be overly complicated. There needs to be a showing, and I agree that the burden should be on the prosecutor based on their access to the resources and their responsibilities to retain records, to show by clear and convincing evidence that the jury was not properly instructed. That the court could do that in several ways. The court could require the prosecutor.
To show that they were properly instructed.
Yes, yes,
Okay.
correct. I'm sorry, Your Honor. The court could do that in several ways. The court could require the prosecutor to start this process by filing a motion. This court could amend 6500 or 6.429 if they would like the defense to start this process. Say, hey, I'm entitled to a Langston resentencing hearing. If this court is looking at the resentencing piece. There has to be a vehicle to start this process for these folks who are still incarcerated pre-Aaron, which at our last count is about 93 people who are incarcerated pre-Aaron. We don't know how many of those folks had proper instructions, but they need to get into the trial court, and it needs to be done in a timely basis. So we know that if this court is looking at amending 6500, for example, there are no time limits there. But in this particular circumstances, because of the fairness at issue here, there should be a time limit where this needs to be resolved within a certain amount of time. Whether that the prosecutor needs to initiate or whether defense counsel needs to initiate, and people will need to get lawyers as well, that process has to start in the trial court, and it should be started quickly. Again, the simpler remedy is for this court to hold that it's retroactive, that Aaron's retroactive, and folks can either get a new trial or perhaps some other sentencing remedies there as well, too.
Counsel, so what is your legal argument about why the prosecutor should have the burden? I understand the argument, they have the records, so there's a fairness issue, I understand, but is there something more that's rooted in case law, or usually the defendant has the burden?
I understand that, and I do understand, and I take the prosecutor's point about Taylor, the prosecutor seeking to change the status quo, so it should be their burden here. I think that I don't have a great answer for that, to be honest. I'm going to be candid with the court, but out of fairness, again, this is an issue of fairness. These folks, especially the people on direct appeal who raised this very issue and didn't have correct standards, have been serving decades in prison, unnecessarily beyond what the jury verdict allowed for. And so in those circumstances, it does seem out of fairness to these people who have experienced this incarceration, if their jury wasn't properly instructed, that initial burden should fall on the prosecutor.
Counsel, you said in passing that when describing the simpler remedy would be to order a new trial, or I think the phrase you used was some other sentencing remedy. What are you envisioning?
In some of the orders pre-Aaron from the Court of Appeals, where people were not properly instructed, the Court of Appeals reversed and remanded for a new trial or entry of a conviction on manslaughter, because that's what the jury verdict allowed for. So I think in these circumstances, if the prosecutor didn't want to retry somebody after a retroactive holding from this court, the parties could come to an agreement on what they should be resentenced on, either the underlying felony or manslaughter. Or if the parties might not agree, so maybe this guidance from this court would be most beneficial and helpful. But those are the other remedies. If the prosecutor doesn't want to retry, resentence on what the jury verdict allowed for, which is conviction on an underlying felony or murder without malice.
Okay, thank you.
And I will collectively reserve the rest of our time for rebuttal.
Good morning.
Morning.
May it please the court, Eric Christusha from the Attorney General's Office, appearing on behalf of the people. Almost 50 years ago, this court and Aaron redefined malice and abrogated the old common law rule that equated the intent to commit the underlying felony with malice as part of its authority to develop the common law, much like a legislative change. It applied this new definition to the cases before it, but otherwise only prospectively. The request to revisit this decision on retroactivity almost 50 years later is unprecedented and is barred by the rules under 6508D and stare decisis. Moreover, retroactivity was not required by law in any event. Langston's conviction here was constitutionally proper, as his jury received the correct instructions on the definition of malice as it existed at the time of his crime and trial. There are 2 points here. First, Langston's conviction was valid. Langston argues that Aaron provided a definition of malice of what malice has always been under the common law. Not so. It's a fundamental misunderstanding of Aaron. Aaron unambiguously changed the common law. Langston's mistake on that point explains why his other arguments fail. There was no due process violation found in Aaron because the jury convicted him based on the old felony murder definition of malice. And this essentially legislative change to Michigan's definition of felony murder, while substantive, did not have to apply retroactively because the change was not required either constitutionally or otherwise by law. It was basically a change in policy at this court's discretion. Second, Langston's sentence was valid. The people argue that Hall is still good law and that any sentencing relief that Langston may seek should come from the governor or the legislature. But this court's final 3 questions are predicated on a revisiting of Hall, which indicates that this court may think otherwise. Assuming so, only some of the pre-Aaron offenders should get resentencing. Some of the cases pre-1980 are crimes of unspeakable brutality. And the idea that those those sentences are cruel or unusual is untenable. The standard the court should identify would be that the defendant carries the burden, and that's consistent with MCR 6508D and Taylor. The standard should be that the defendant has to show that the evidence of malice, as defined by Aaron, was not clear from the record, and that if successful in getting a resentence, the sentence should be life with the opportunity for parole. So I'm about to delve into this point about this was a change in the definition of malice, because the opinion of Aaron is replete with references to this being a change, because its analysis was a two-part process. It first looked at the statute, and the statute, of course, has no definition of the elements. And it said since it was not defined, it moved to the common law. And its opinion was unambiguous, that the common law as it existed at the time was that it was, here's a quote, "Our opinion today is limited to the question of whether we should continue to recognize the common law rule which allows the mental element of murder to be satisfied by proof of the intention to commit the underlying felony." Once that's understood, that this was a change, it's directly relevant for both the due process claim and the claim about retroactivity. The court really shouldn't be getting there in the first place. I think, Justice Walsh, you're right. It's barred by 6508D3, and it's barred by stare decisis. Frankly, if stare decisis does not apply to this retroactivity decision, it's hard to figure when it would apply. Because the point is, if these defendants had gotten relief, I assume it's just talking about the cases on direct review, in 1980, and Mr. Langston, he may have gotten a plea on remand. But Mr. Wilson, the co-defendant, he shot and killed this woman. They had overwhelming evidence that he was a direct perpetrator. They would have re-prosecuted him, and he would have been convicted. The harm to the prosecution and to the people under the retroactivity piece of this, on the conviction, is at its highest. The ability to re-prosecute, and they've even talked about re-prosecuting, I mean, nobody will be re-prosecuted. That's an obvious point. The ship has sailed. The question of retroactivity was not required. Justice Fitzgerald, he was a sophisticated justice. He knew what was going on. The point is that there was no missing element. That's their claim. The claim is, under In re Winship, there was an element that wasn't proven. It's not true. All of these convictions were validly obtained. In fact, Justice Levin says this in his dissent in Lamar. He says they were valid under the law as it existed at the time. The element that had to be proven pre-1980 was the intent to commit the underlying felony. That was the mens rea. That was the malice. That's what the law provided. Mr. Langston, Mr. Aaron, all of them were convicted properly under the law as existed before 1980. There is nothing wrong with these convictions. That's why the change in the elements was a part of this court's essentially almost like a legislative function. If you read Woolfolk, it talks about how this court can change the standards according to contemporary standards. Well, the very point of that is it's like a policy change. It doesn't have to be retroactive, and that's what, in fact, this court in Sexton provides that analysis and quotes Justice Cardozo about the fact that the federal Constitution has nothing to say about the change in common law. So consequently, it seems to me the real meat of the claim here is that you have people like Mr. Langston and others within this cohort of 93 offenders who were aiders and abettors. And that the question is life without parole a fair sentence for those offenders under this court's cruel or unusual punishment jurisprudence? And I recognize that Hall has taken on this, I read the Taylor opinion. Of course, the question was, will it be retained? And we'll leave it for another day. So I understand that. I mean, my point is that this is something for which the legislature and the governor can take action. But if the court's not persuaded by that first order answer, the second order answer is, it's a three-part test of what should happen. First, it's the defendant's burden. In fact, Ms. Simbelman was quite frank that it's clear. The idea that somehow the resentencings are for any pre-Aaron offender, it's the prosecution's burden to show by clear and convincing evidence that the instructions were given consistent with Aaron it's an upside-down way of looking at it. There's no presumption of error, right? I mean, the fact I was convicted before 1980 doesn't mean I had an error in my trial. I have to show error. The defendant has the burden of showing error before seeking relief. And so here, on the sentencing part, under 6508D and under Taylor, as a moving party, they're trying to upset the status quo. the convictions were valid. The question is, why is the sentencing a problem? They have to come in and show that the instructions didn't require a finding of malice under Aaron before Aaron was decided. That would be their burden, and it would be a two-part test. First, to show that the instructions were pre-Aaron instructions, and second, to show that the evidence of malice under Aaron, as defined by Aaron, wasn't clear.
What's your response to their argument that under that test poses Sixth Amendment issues? Because regardless of whether or not there was evidence, there is no conviction for a proper conviction.
There was no finding of malice.
Right.
Because ultimately, I'm going to push back on there's no proper conviction because, under the old rule, it was a proper conviction.
Right.
The point was there's no finding of malice. The way the Sixth Amendment jurisprudence runs, and of course, the Skinner case, I think, provides a helpful analysis because this very analogous issue arose in the federal system under the death penalty cases. And you have Edmund and Thiessen. I think they're perfect analogies because the United States Supreme Court, looking at the death penalty, it's not life without parole, but the death penalty, said, we have these offenders. They're going to be executed, right? And there's been no finding that they had intent to kill or were involved in the murder itself. That is an Eighth Amendment violation. So in Thiessen and Edmund, they said, we're going to go through and require a review of the record, essentially, and determine if they were culpable, whether the evidence on the record was of sufficient culpability to allow the death penalty to remain. There's then a Sixth Amendment analysis that is provided with respect to this, and this court quotes Lefebvre on that very issue, cites Thiessen, cites Edmund, and says, and the analysis that this court quotes is the sympathetic analysis or the proved analysis, which says there is no Sixth Amendment violation because the fact finding that gives rise to a Sixth Amendment violation is one that allows a greater punishment. The question is, what did the law require based on the verdict? Under Michigan law, before 1980, if you had the intent to commit the underlying felony and someone died, the law required a life without parole sentence. So the only thing that fact finding can do here is to pull down the final, what the verdict requires. Any fact finding that's made that reduces the punishment does not run afoul of the Sixth Amendment, and that's exactly what this court quoted in Skinner, citing Thiessen and Edmund. And I think it's worth quoting it because I think it is directly on point. This court's analysis, and it's not just on point and authoritative, but it also just fits with the Sixth Amendment jurisprudence, but it says, this is footnote 17, page 125 of Skinner, which says, quotes this Nebraska case, Ring does not require a jury determination of Edmund Thiessen findings because the Edmund Thiessen determination is a limiting factor, not an enhancing factor. And then it quotes Lefebvre. So far, lower courts have rejected arguments to equate the factors which is an Eighth Amendment law required for death eligibility with elements. The rules in Thiessen and Atkins have instead been treated as defenses to, not elements of capital murder. This court quotes the very analysis that explains why additional fact findings that pulls down the required sentence by the valid conviction is not going to run afoul of the Sixth Amendment. So then think about this process. You have 6,500 motions. The defendant carries a burden. They would then have the obligation to show both that they didn't get a Aaron instruction. So now there's been no finding of malice as defined by Aaron. And then they have to show that the record of malice was not clear. And this one of the reasons, the thing that's pressing on this, and my thought about the sentencing piece of this, is the very thing that Ms. Simbleman flagged, is that I've been identifying these other cases. Because obviously Mr. Langston comes within this cohort of 93 as one of the more sympathetic members of that cohort. We have all the pre-sentence investigation reports of these 93 offenders, and I've only identified those that are available from the record, but there are some cases of just, breathtaking brutality. And the idea that those offenders have an unconstitutional sentence it's an untenable conclusion. The question would be, let's say Mr. Victor Medina wants to bring forward his claim. Now, his case is a public one. He brutally stabbed someone with a butcher's knife. He was the principal. So the question is, let's say he had a pre-Aaron felony murder instruction. So let's say he can get through the first step. He would still have the obligation to show that the evidence of malice, as defined by Aaron, is not clear from the record. Why does that make sense? Is because it is his burden. And the reason I haven't said sufficiency is essentially too low a threshold for the prosecutors if someone's going to be entitled to relief. Even here, in this case for Mr. Langston, the Michigan Court of Appeals said that when it provided relief, it said it could be re-prosecuted for felony murder because under the depraved heart theory, his participation may be sufficient. The question of what constitutes clarity, the very test that Ms. Zimmelman identified, I think is consistent with the way Edmund and Thiessen has looked at it. If you're a principal, the idea that your conviction is now cruel or unusual is a very weak claim. That you have the obligation to show the evidence of malice as defined by Aaron is not clear from the record. And the idea that somehow the records are going to be insufficient for this because the defendant didn't know of his obligation to try to defend this legal theory, in fact, it has it in reverse. If the prosecutors who weren't placed on notice of the obligation to prove this, and so they wouldn't have necessarily placed on evidence of all the malice because it wouldn't have been necessary. It doesn't matter because, of course, the question is really what was presented by the prosecution, because the defendant's not going to essentially convict himself by testifying. Sometimes it happens, but in an ordinary case, when the prosecution wants to show the strength of the case or if there's an evaluation of it, you look at the case in chief. Anyone who's done a lot of briefing knows you're going to pull your case and describe what happened. Well, insofar as this makes it harder for the prosecutor to identify evidence of clear malice because it didn't have an obligation to show malice as defined by Aaron before 1980, the harm only goes to the prosecution with respect to this. Because the prosecution would have had the burden in the first place of establishing the case in chief, and because that element was not required to be proven because the elements didn't require one of the three intents as defined by Aaron, the only person who's kind of suffering a loss, or the party that would be suffering a loss would be the people themselves. It doesn't matter. I'm not relying on it. I mean, if this court's not going to reaffirm Hall and say he's not entitled to sentence relief and Mr. Langston loses, then it seems to me the court would place the burden on the defendant. He has to move under 6500. He files in the trial court. He has to show the instructions, and if he did get a pre-Aaron instruction, which was consistent with the law before 1980, there would be then a review of the record. And ultimately, he would have to show that the evidence of malice was not clear. It's not that it was sufficient, not that it was just a sufficiency, but rather clear. It's a clear and convincing standard. It's consistent with Taylor. In fact, insofar as Ms. Zimmelman has suggested that Taylor would be the model, that is the model. Clear and convincing evidence. The point, though, is the defendant carries the burden, so it comes at it from a different direction. The defendant has the obligation of showing the prior instructions were not Aaron instructions, and some may have been, but the law didn't require it at the time. And the second is that the evidence was not clear. And then, if that's been established, the relief for sentencing at that point would be life with the opportunity for parole. And I think the guidance from that comes from this court's decision in Bullock. Bullock had a very similar posture, right? You had life without parole, sentences in place. And they were all, this was not the status of the offense, but this was not the status of the offender, but the status of the offense. These were all drug offenses. And the court said, we're going to, that life without parole for a drug conviction is a violation of Michigan's cruel or unusual punishment. But here's what the court said when it talked about the issue of remedy. It said, we conclude that the most appropriate remedy under the circumstances is to ameliorate the no parole feature of the penalty. We therefore strike down with regard to these defendants and all others who have been sentenced under the same penalty and for the same offense that portion of the statute denying such defendants the parole consideration otherwise available. That's how this court treated it. In Bullock, that seems to me to be the point of reference. I mean, the guidance that this court has about what should be the basis for the remedy if the defendant's able to show that the evidence of malice under Aaron was not clear. I also want to address this issue about the categorical prohibition. I mean, one of the arguments being advanced by Mr. Langston and by CDM is that if you look at Graham, it talks about categorical prohibitions, and so consequently there shouldn't be this this as-applied analysis looking at the cohort of the pre-Aaron offenders. But it's a misunderstanding of Graham. Graham actually cites the Thiessen-Edmond line of analysis. Thiessen and Edmond are unambiguous about looking at the record to determine what the nature of the gravity of the offense was. In other words, when you have a categorical prohibition under Graham for the nature of the offense, the analysis allows a review of the record to determine whether it would be one of those offenses. So the question was for both Thiessen and Edmond whether the offense there was one without an intent to kill, intent to participate in a murder. And so in Edmond, the court did a review of the record and said the record was insufficient to support that conviction, so consequently the death penalty had to fall. In Thiessen, if you read the court's analysis, it looked at the record, it did an analysis, and the suggestion is it sent it back to the Arizona Supreme Court, but that based on its review of the record, these convictions were going to stand, even though it was a categorical prohibition. But the question of whether that category applied was a record-sensitive analysis. The same thing happened, in fact, in this court's analysis in Lyman. One of the questions was, well, what about the Lorenzen factors? There's never been this as-applied analysis under Lorenzen. If you look at this court's final analysis in Lyman, it talked about, because when it did an analysis about the gravity offense, as you recall, the Lyman case is Sex Offender Registration Act. It was a whole set of offenders who were convicted of one of three categories, unlawful imprisonment, kidnapping, or child enticement. And none of them included a sexual element in the convictions. So the question is, were all of these offenders entitled to relief? Well, what this court did in its own analysis under the Bullock or Lorenzen factors is it went through the factors, but the first factor analysis under Lyman regarding the gravity of the offense is the court actually looked at what Mr. Lyman had done. It didn't look at what the conviction said. It looked at what he did. Defendant held his family hostage in an imminent fear for their lives for more than 12 hours, resulting in convictions not only of unlawful imprisonment, but also torture and others. The court then went on in talking about who would get relief. It's those whose crimes lacked a sexual component. Now, it dropped a footnote at that point and talked about the narrowness of the holding and how it's workable. And then it identified the fact that in the Michigan State Police amicus brief, 295 cases have been identified for which you had one of those three convictions, and how 281 had received relief. But this court notes, sympathetically in citing this fact, it said 14 registrants who were convicted of non-sexual offenses, but whose offenses had a sexual component remain on the registry. In other words, there were 295 in this cohort, but only 281 got relief because 14 of them on the record, based on a record analysis, had a sexual component, even though that was not a part of the conviction itself. In other words, this court's analysis in Lyman tracks the very thing that I'm suggesting should occur here, which is not all 93 of these offenders, if they got a pre-Aaron instruction, would be entitled to relief. It would be only those who can show that they're part of this category of the nature of the offense was one that did not include overwhelming evidence of malice or clear evidence of malice as defined by this court in Aaron. And of course, what's driving my thinking on this is, when I looked at those pre-sentence investigation reports, some of them are harrowing, right? So if I think about Fletcher Small, the evidence of his case this is a matter of record. It's 120 Mishap 442, where he and two other men, what the court said was a brutal and bizarre attack on an 86-year-old woman. I mean, torturing an 86-year-old woman in which the three men over a 4-hour period were all active participants. The idea that he can come back and say, well, my sentence for life without parole is cruel and unusual is just an untenable position. This court, if the record on that is clear of malice, like it is for Mr. Small, then he wouldn't be entitled to resentencing. And so
what about, you've talked a lot about the people where there is, you believe, demonstrated malice. What about the ones where there's no demonstrated malice? Then what?
Well, it seems to me that, my first order argument was, of course, Hall stands and they have to wait on the governor or the legislature, but obviously the questions that were asked thereafter suggest that's insufficient. If the evidence of malice is not clear, then life with parole, as Bullock, with the opportunity for parole, would govern. Now, one of the things, too, in this court's analysis, and I know this has been raised by either CDM or Mr. Langston, is that parole with the opportunity for life, Stovall cast some doubt on it. In fact, like, boy, this life means life, and it's a real problem, and so parole opportunities are not really valuable. I mean, it's really just going to end up serving a life sentence. And one of the things that happened in Stovall is the Michigan Department Attorney General filed an amicus brief to say, you know, life means life. That used to be the case. It's no longer. There's been a sea change at the Department of Corrections and with the parole board. And so in that amicus brief, the Department Attorney General provided the new numbers on parole consideration. And so, like, and these are people who just have served their minimum. These offenders have all served at least 45 years. They're going to be treated very differently by the parole board than someone who comes in after 15 years is asking for parole. But nonetheless, if you look at the numbers in 2021, of the 570 who were interviewed, 89 received parole. That's, 15.6%. From 2016 to 2021, it was about a 17% grant of parole rate. Now, that doesn't really sound as high for all these offenders, but of course you have to think those offenders who are coming in for the first time or the second time, 15 years, 20 years, 25 years, these offenders have all served 45 years. I mean, it seems to me that the only, I don't know if there's any public information, but I know the Department of Corrections had a set of offenders back some years ago, 2012, in which you had what they called the Allen offenders, but they didn't make them eligible for parole if they had both a life with parole sentence and a term of years, because the idea was there was no minimums that could be added together. Well, in any event, this cohort of offenders, after the Court of Claims ruled against the department that they had to be eligible for parole after they had served at least the minimum of their parole eligibility plus the term of years added together would be their earliest release date. That would be the term. In any event, this is a cohort for whom, if the court were interested, I could track down the numbers on it and find out if this is a cohort for whom they were granted parole at a very high rate. The very point, though, is parole eligibility is not a dead letter in Michigan. And for offenders who've served 45 years, who virtually as a cohort, for those particularly where they were ones who were eligible for release, where they were essentially aiders and abettors and had lesser culpability, the idea that this parole eligibility would not be beneficial to them and they would not be paroled at a significant rate, I think is a misunderstanding of what's happening in the Department of Corrections and the parole board.
Counsel, I'm wondering if you could respond to the argument about sort of the cruel or unusual analysis about whether it's unusual that there's this class of defendants that's particularly some that had direct appeals and they were put in abeyance and then treated differently than the defendant in Aaron. Well, in fact,
I don't think that cuts on the, well, I mean, I guess that could be reviewed on the cruel and unusual piece of it, but Judge, there's an opinion from Judge, from the Federal District Court, which examined this very question about the decisions about getting relief for the cases before the court and those who are also pending on direct review not receiving. Judge Lawson had an opinion on this. In fact, if the court's interested, I could provide it after the case. I can't remember the name of the case offhand, but he provided a very analysis on this and said there is no equal protection violation for providing only relief to those for the cases that are before the court and not others on direct review, because what's driving it is that there was no entitlement to relief. In fact, if this court looks at what it did in People versus Stevenson, which is the year and a day rule, back in 1982, it decided not to apply. It was an adverse ruling for the defendant, but it decided to make it purely prospective. It didn't even apply to the case pending on review. It made it purely prospective. It didn't apply to anybody, but said this is the rule going forward. We're not going to apply it to the defendant. One of the considerations that was driving it was notice. And I think that touches a bit on the retroactivity piece, too, because the idea that every substantive change has to be retroactive to cases that are final on direct review runs right up against what's happening in the development of the common law. In fact, in the Stevenson case, the court had noted that it can be both an expansion or a contraction of the interests of the defendant. And so here's a quote from Stevenson. The court would, if it were defined as only being an expansion, the court would lack the power to reverse itself and expand liability by readopting, for example, the felony murder doctrine. In other words, in Stevenson, this court even floated the idea that the court could, which I don't think is on the table, could reinstate the old common law definition of felony murder, because that would be a substantive change. The idea that that would have to be applied retroactively doesn't make any sense. But circling back to what this means for you, Justice Welch, is this was grace. In other words, nobody was entitled to the benefit of this rule. So the fact that a court applied it to 3 and then Mr. Wilder and then the 5th case they had no legal right to that relief, to have their conviction set aside. Or even on the sentencing piece of it, the same is true, that there is nothing cruel or unusual about only a certain set of people being entitled, receiving the new rule, because that's how new rules are provided. If they're not required in law, you can give it to the party that's before you. In fact, you don't have an obligation to. But the fact that the court limited it to those 5 was not a constitutional problem whatsoever. So I guess I'll sum up if there's no further questions, which is there are really 2 basic points. The first is the conviction of Mr. Langston was perfectly valid. It was consistent with the law as existed at the time. The jury did have to make a finding of malice, and that was the intent to commit the underlying crime. So the conviction is perfectly valid. The question I think that's pressing for the court is the sentence of life without parole fair? Obviously, there's been a whole set of cases where this court is using cruel or unusual punishment on Michigan's constitutional basis and revisiting things. And so I think there were 586 offenders in the Poole-Taylor cohort. It seems to me that on the second point, the lead position of the people is Hall should govern. But if the court doesn't accept that Hall should govern, then the second order answer is it's the defendant's burden, is the defendant's burden to show that there was error in the first place. On the question of sentencing, in order to show that it's possible that my sentence may be cruel or unusual punishment, you have to show that you didn't get an error in instruction and that the evidence of malice on the record under Aaron was not clear. And if you're able to do that, you'd be entitled to a life with parole sentence. And so for Mr. Langston, if the court were taking that second approach with respect to his sentencing, I think the proper action would be then to remand to the circuit court to make a determination in the first instance whether there was clear evidence of malice on the record. Because we've seen that the instruction, because the people are not contesting that this was an error in instruction, we're not advancing that point. So the first step had already been established. So the second step that he would have an obligation to show before Judge Brickley is that the evidence of malice was not clear, and if so, that he would be resentenced to parole with the opportunity life with the opportunity for parole. If there's no further questions, I'll stand down. Thank you.
Thank you.
Justice Welch, thanks to my colleagues, I have a better answer for you on why the burden should rest with the prosecutor here. As far as initiating the process in the trial court, that can rest with people in this class if this court determines that we should start the process. But there's 2 reasons why the burden should rest with the prosecutor. First, according to Winship and principles of due process, it was their burden in the first place to prove beyond a reasonable doubt that somebody had all the elements to make them guilty of felony murder, as defined by malice. The second, if this court gets to the sentencing rule here, the holding should be that life without parole is an unconstitutionally cruel or unusual punishment if a person's jury was not instructed consistent with Aaron. So that, therefore, the court would be vacating those life without parole sentences, and it's the prosecutor's burden to show that a life without parole sentence would be appropriate, i.e. that the jury was instructed consistent with Aaron. So those are 2 reasons why the burden should rest with the prosecutor. I also want to go and talk about culpability a little bit, because the prosecutor really focuses on, as he says, the harrowing facts of some of what happened here. This court knows, of course, that in Zarnecki, Taylor, Parks, Poole, that it hasn't looked at the particular facts of those offenses, which also were all murder. But rather, this court looks to culpability. And again, looking at Aaron makes the connection between criminal liability and moral culpability. Bullock tests about an individual has lesser culpability because he lacks the necessary mens rea or actus reus, but is still given the most severe punishment. Graham talks about twice diminished moral culpability for kids. Parks mentions 19 times the idea of culpability in this court's opinion, and says it would be profoundly unfair to impute full personal responsibility and morally guilt to those who are likely to be biologically incapable of full culpability. These folks, whose juries were not instructed, are not legally culpable here. There's not biologically culpability, although I would point out for this court that several people who are still incarcerated pre-Aaron are entitled to resentencing under Poole, Zarnecki, and Taylor, including one of the factual scenarios that the prosecutor referenced. And Edmund from the U.S. Supreme Court and Lockett and Tyson all talk about the connection between culpability, intent, and the proportionality of a sentence. And where the, at a resentencing here, the trial court judge is going to impose a sentence that is consistent with a person's level of culpability. Life without parole is off the table if the jury was not properly instructed consistent with Aaron. But because most of the underlying felonies here are Class A, parolable life could be a sentencing option for a trial court judge at resentencing. Is the trial court judge at a resentencing that will look at the person's individual culpability and fashion a proportionate sentence, which is what this court requires of our trial court judges. What's the proportionate sentence to the offense and the offender? That's what will happen at resentencing for these folks whose juries were not properly instructed. I also want to talk briefly about the Sixth Amendment. This court in Skinner said, such a sentence, and they were talking about life without parole for kids, such a sentence is necessarily authorized by the jury's verdict. It is different here because life without parole for felony murder without instructions consistent with Aaron is not authorized by the jury's verdict. So we do have Sixth Amendment problems. And the prosecutor relies on Tyson and Edmund. Those were both decided prior to the Supreme Court's decision in Apprendi. So their relevance when it comes to the Sixth Amendment question is lower. But what we do have is Skinner telling us that if the sentence is authorized by the jury's verdict, there might not be any Sixth Amendment problems. That's fundamentally different than what we have going on here. And the Court of Appeals acknowledged as such. The prosecutor pointed in Mr. Langston's case that the Court of Appeals said, well, there might be an inference here of malice. The second part of that sentence was, but that's a question for the jury. The Court of Appeals said that for Mr. Langston, and that's what should be here. It really was a question for the jury, and we can't go back and eliminate the harm that came from improper instructions. So this court should remedy that today. Again, the first holding should be that Aaron should be applied retroactively. If this court doesn't go there, the holding that we are asking for is that life without parole is an unconstitutional sentence if the person's jury was not instructed consistent with Aaron. And that stems from this court's cruel or unusual punishment jurisprudence, the definition of culpability found by this court in the United States Supreme Court as well. That's the unconstitutional sentence, that's the holding, and these folks go back to the trial court for resentencing. If the court has no further questions, I thank you for your time.
Thank you. The case will be submitted, and that concludes our call for today.